Hafidades and Biba Masamoru, Toda Samzu. This hearing by the Committee on Innovation, Economic, Workforce, and Youth Development is called to order. It is now 10:06 a.m. For the record and in accordance with 5 GCA Chapter 8, subsection 8107, public hearing notices were sent out on Tuesday, March 20th, 2018, adhering to the 5 days notice, and a second public notice on Friday, March 23rd, 2018, 48 hours prior to today. In addition, this hearing was noticed on the legislature's website, www.guamlegislature.com. Written testimonies may be submitted by emailing Senator Bisco Lee at guamlegislature.org, or you may hand deliver them to our office at 163 Chalan Sancho Papa here in Hagåtña. Joining me here this morning are my colleagues, Vice Speaker Terlahi, Senator Joe San Agustin, Senator Mike San Nicolas, and Senator Jim Espaldon. And I'd like to thank my colleagues for joining me. On the agenda this morning, ladies and gentlemen, are Bill number 426-34, introduced by Michael F. Q. San Nicolas, an act to add a new subsection Q to subsection 58104 of Article 1, Chapter 58, Title 12, GCA, relative to establishing a qualifying certificate for a business with at least $5 million in unrepatriated profits earned by at least one foreign subsidy, which offers a 75% rebate for income tax paid to the government of Guam on repatriated or deemed repatriated profits. And Bill number 250-34 LS, introduced by Regine Bisco Lee, Thomas C. Atta, Teresa M. Terlahi, Joe S. San Agustin, B. J. F. Cruz, Talina C. Nelson, William M. Castro, Fernando B. Esteves, Tommy A. Morrison, Luis B. Muña, Mary Camacho Torres. An act to amend subsection 7119A and C, and to amend subsection 7120, and to add a new subsection 7119D, all of Chapter 7, Title 22, Guam Code Annotated, relative to developing a local skilled workforce on Guam by increasing registration fees of non-immigrant temporary workers. I'll now give the floor to Senator San Nicolas to elaborate on Bill 246.
Thank you, Madam Chairman, for hearing Bill 246-34. Bill 246-34 is an act to add a new subsection Q to section 58104 of Article 1, Chapter 58, Title 12, Guam Code Annotated, relative to establishing a qualifying certificate for a business with at least $5 million in unrepatriated profits earned by at least one foreign subsidiary, which offers a 75% rebate for income tax paid to the government of Guam on repatriated or deemed repatriated profits. To simplify, the purpose of this bill is to take advantage of what has captured the attention of many multinational United States corporations with the passage of the Trump tax reforms. These tax reforms specifically adjusted the tax rate that is assessed on money that is brought back into the United States. Historically, if a company earns money in a foreign country, if they bring that money back into the United States, they would have to pay the full corporate income tax rate, sometimes as high as 39.5%, depending on the income of the particular company. With the Trump tax reforms, they lowered that tax rate all the way down to 15%. And so before the Trump tax reforms, multinational corporations were banking large sums of money in the hundreds of billions of dollars overseas and not bringing it back into the United States because they did not want to have to incur the tax. Now that the tax rate has been lowered, many of these large multinational corporations are considering repatriating these hundreds of billions of dollars back into the United States to take advantage of the lower tax rate in order for them to be able to reinvest those proceeds into U.S. assets or to pay out dividends to U.S. investors or to buy back some of their U.S. incorporated stock. The situation we have here on Guam is very, very unique because in 1965, Governor Manuel Guerrero signed Bill 167 into law that created the qualifying certificate program. And this qualifying certificate program allows Guam to be able to rebate taxes, particularly federal taxes, and in this instance of interest is the corporate income taxes that would be paid on repatriated profits. The law that was passed in 1965 also just so happened to fit within a particular window where we had a provision in the Organic Act at the time that basically read that any law that was passed on Guam that the Congress did not react to within 1 year automatically became a provision of the Organic Act. And so what happened when Public Law 8-80 was enacted on July 23, 1965, 1 year after that, July 23, 1966, that technically became an Organic Act provision. Since that time, Guam has been issuing out qualifying certificates, and this particular law that was enacted in 1965 was tested in 1977 in the case of Ramsey versus Chaco, where they challenged the changing of the law to amend the percentage of income tax that was going to be rebated with respect to a particular qualifying certificate at the time. This went all the way to the Ninth Circuit Court. And the Ninth Circuit Court actually upheld the ruling, and the court concluded that the Congress's failure to annul the original rebate bill within 1 year constituted an implied approval under former Section 19 of the Organic Act. So basically what we have here in Guam is a very, very unique opportunity where we have the ability to rebate corporate taxes. This ability has been technically incorporated into our Organic Act with the particular section that was enforced at the time, and it was validated and reinforced by the ruling of the Ninth Circuit Court. What this bill now intends to do is to take advantage of this very ripe opportunity where we have a lot of these United States multinational corporations trying to maximize the tax advantage of the Trump tax reforms and seek as much tax relief as they can in repatriating their profits. Under the Trump tax reforms, they will receive relief at the rate of 15%, which is lower than 39.5%. But on Guam, if we provide for an additional rebate on top of that, we can become a very, very attractive destination for these multinational corporations to book their repatriated profits here on Guam. And so what this bill would do is it would rebate 75% of the total tax that they would pay under the new Trump tax reform. And so right now, at 15%, if we rebated 75% of that, it'll be roughly 3% in taxes that these corporations would pay, and that 3% would be retained here on Guam. The remaining savings of approximately 12% will be booked into the company's profit margin, and it would give them a serious competitive advantage. If you have 4 different multinational corporations engaged in the technology business, all of them want to repatriate profits to be able to reinvest those proceeds. If one of them takes advantage of the opportunities presented in this bill, they would have a serious billion-dollar advantage over their 3 other competitors. And so there's a very high likelihood that if we are able to pass this law and create this program, given the fact that it's already been upheld in the Ninth Circuit, we may be able to attract very, very large sums of money to be booked here on Guam as repatriated profits. Now, just to simplify the math, if we just have $100 million booked here as repatriated profits, that's $3 million in taxes that we will collect that we would have otherwise not have had anything to do with. If we have $1 billion, that's $30 million. So there's a very good likelihood that we can capture some significant revenue if we implement this program. And so what we're attempting to do, Madam Chair, with this bill is to allow for the Guam Economic Development Authority to be able to offer this particular type of qualifying certificate, where we will rebate a percentage of repatriated profits in order to attract these multinational corporations and have them pass through their repatriated profits through the territory of Guam. So we're looking forward to testimony from the public. We're very, very hopeful that this can become a really good revenue-generating opportunity for the people of Guam in a way that isn't going to impact our infrastructure. It isn't going to impact our services. It really would just be a mechanism for us to be able to have specific monies pass through the territory and be taxed at a very, very special rate that only Guam is able to offer and that many large companies are currently looking at given the circumstances that were created with the Trump tax reforms. So thank you, Madam Chairman, for giving us the opportunity to hear Bill 246-34. Thank you, Madam Chair.
Thank you, Senator Nicholas. At this time, I'd like to call Individuals who have signed in to testify, please come forward and be seated when your name is called and identify yourself for the record, and we can proceed with your testimony. Mr. Joe Bradley is present in a personal capacity. Thank you, Mr. Bradley.
Thank you, Madam Chair. By way of identifying myself, I'm Joe Bradley. I am an economist by profession. I've lived in Guam for over a third of a century now. Worked for the Department of Commerce, for Bank of Guam. I've done consulting, I've done teaching at the university, and so forth. I have not prepared written testimony on this legislation, but I would like to provide oral testimony. And that is very simple, straightforward, and basic. I think it's a good piece of legislation. I think that it has the potential to be very favorable to the revenues of the government of Guam. And I think that your $3 million would be a drop in the bucket. There are some things that I think should be said, though, and that is, first of all, Congress is already looking at amending the Tax Cuts and Jobs Act because there were so many, shall I say, errors in that legislation. They passed a bill that part of the law is handwritten in the margins of the bill. We don't do that. But they are preparing to amend the new tax code, and so I would recommend a couple of things with regard to that. Quietly and quickly, as best you can. Second, I don't think that a 75% rebate would be necessary. I think a 25% rebate would be sufficient, in that it knocks that 15.5% tax rate on the repatriation of funds down anywhere below any other jurisdiction in the country could provide. So that's kind of what I have to say.
Thank you, Mr. Bradley. Senator Espaldon?
Thank you, Madam Chair. Mr. Bradley, it's always a pleasure. Quietly and quickly, how do you perceive, or how do you foresee that? I mean, should we pass this law, right, and enact this law? What is, I mean, how do you get the word out there and be quiet about it?
I guess what I'm saying, quietly and quickly, in trying to get in under Congress's radar on that, because they would say, oops, and try to make a change, perhaps just simply repealing any law that we pass, because there is that one-year window for congressional repeal of Guam laws.
Okay. But I mean, in a practical sense.
In a practical sense,
right?
I think
how do you broadcast that the opportunity is available right now?
I think it would be useful for perhaps the Guam Economic Development Authority to directly contact those firms that have large offshore cash holdings.
Thank you.
There's another provision in the law with an 8% tax rate on repatriation of other assets, but I don't have any idea what they might be talking about there.
Right. Okay. Thank you, Mr. Bradley. Madam Chair.
Senator Torres?
Yes, in your estimate, is this bill feasible?
I think it is. There could be a couple of obstacles. One, the process of repatriation itself, that money has to go somewhere when it arrives in Guam, and that would probably be the banking system. Very large amounts repatriated suddenly would put a strain on the capital ratios that banks are required to hold in reserve against their assets. There are actually 4 different capital ratios we have to meet. There are ways to resolve that, but I'm not prepared at this time to divulge those.
I think that's what I'm trying to wrap my hands around is, are we structured to actually implement this type of a program? And also, does Guam have the capital investment and the infrastructure investment to accommodate these sorts of businesses? And that's what I'm wondering is, are we at that maturity level to actually realize this kind of entities coming into our jurisdiction and setting up the way it is? It is a very ideal situation, no doubt, but that's whether it's a fit for Guam right now, or whether, I mean, even insofar as our tax systems and the fact that we're a mirror code, you know, I'm not quite understanding whether it's as easy as contemplating a measure like this and having it take effect right away. And that's kind of what I'm trying to grasp at, is that.
What I envision is not that these firms would set up shop here permanently. They would take out a business license, create a presence in Guam. It may be what they call a top shelf corporation at some accounting firm, and merely have a legal presence without a physical presence. So I think that part of it would be fairly straightforward. The second part of it, the movement of funds, they're not going to be bringing in bales of cash. It would all be electronic transfers. And so the infrastructure exists for that.
I think I'll need to look at this a little bit more, because the concepts are there, but you know, some of us are very practical, and it's that practical application that and maybe that's what's really behind the ideas that you have that you can't express so openly. And maybe that's what I'm struggling with, is trying to determine if you know, if in fact it's a practical program that can actually take hold if we were to do it without being in violation of a lot of the tax implications that are set in place, you know, and the relationship that we have with the U.S. Code.
Well, I think that we have finally come to a point where it's an advantage to have the mirror code, because in order to repeal that part of the code for Guam, they would have to repeal it for the entire nation. And I don't think that they're wanting to do that. Now, there are a couple of other avenues through which Congress could void whatever we are trying to do. They could insert an amendment into the new tax code saying except for, or they could simply repeal the local public law unilaterally. We fall under that territorial clause in the Constitution, I'm sorry. But there are also methods in which banks can expand their capital base to be able to accommodate large inflows of liabilities.
No, I have no further questions. Thank you. Thank you.
Thanks.
Thank you, Mr. Bradley. I have a few questions for you. Many countries have some sort of tax abatement policy to attract companies to do business in their country. So this bill would set up a tax rebate program. Could you maybe explain or tell us the difference between a tax abatement program and a tax rebate, as this bill proposes?
Yes, a tax abatement is basically forgiving a tax liability. Under our qualifying certificate program, property taxes and gross receipts taxes can be abated, meaning that the recipient of the qualifying certificate would not pay those taxes. But because the Internal Revenue Code, the income tax code here, is here by federal law rather than by local law, we cannot abate a federal tax, but we can rebate meaning that the qualifying certificate recipient would have to pay the tax, and then the tax would be rebated to them. They have to pay the tax under the Internal Revenue Code, but then that money becomes Government of Guam funds and can be rebated to the QC holder.
Thank you. Guam was placed under the EU's blacklist for tax havens. Could you tell us how this designation might affect Guam as it relates to this bill?
I don't think that it would affect this bill at all, because the European Union has made an error. They are thinking that Guam is a nation and that we have our own tax code. The United States has well-developed tax information sharing agreements with the European Union, and and we have a well-developed tax sharing arrangement with the U.S. Treasury Department.
Thank you. Okay, if there are no other questions, I'll turn it over to Senator Siniclas. I think he has a few questions for you, and then to close on this bill.
Okay. Thank you, Madam Chair. With respect to the bill, we definitely are open to, on the floor, having a frank discussion about whether or not 75% is too much to give back. For me, if you're talking about hundreds of billions of dollars, even $100 billion at 3% is $3 billion. I mean, that would just transform the island. So I would go for the full plate and try and make it as attractive as possible. We definitely can have that discussion on the floor. I do want to ask Mr. Bradley, there are two items that I was considering including in the bill, and I wanted to mention in the hearings that we can have the opportunity to do so on the floor if so necessary. One was, in the interest of trying to capture as much revenue in this process as possible for Guam, do you have a position on whether or not we should include a requirement that these monies pass through a financial institution that's chartered on Guam?
I don't think that would be necessary. I mean, sure, I'd love that, but I don't think it would be necessary. In fact, I think that every financial institution in Guam would want to be a beneficiary of this legislation.
Sure. How about licensed to do business on Guam?
Absolutely. That would be an absolute necessity. I imagine if this bill passes into law that there will be people at Citibank who are kicking themselves.
My second question is, I agree with your assessment that we need to do this quickly and quietly. I was also considering adding language in here to create an agent incentive, where if we were to have, if an agent representing or who has an ability to broker this type of arrangement between these multinational corporations and Guam, they could actually be paid a percentage incentive as well for setting up the relationship. And I think that this might also help us to attract accounting firms to be willing to link up their clients with our opportunity. Do you have any opinion to share on something like that?
Well, I've suggested that Guam Economic Development Authority would be a proper channel through which to invite these firms to repatriate funds here. But I basically assume that at least two of the large accounting firms here would also want to solicit interest.
Okay. So just for the record, Madam Chair, we may be considering on the floor, just that it's out there in the hearing, that would be potentially including an amendment to add a requirement that repatriated profits must be handled by a firm licensed to do business on Guam, and also an amendment that would include the opportunity for there to be an agent incentive payment for any representative to broker these repatriated transactions. But thank you, Madam Chair, once again for hearing Bill 246.
If there are no more individuals who'd like to testify on Bill 246-34, we will now move on to 250-34. Thank you, Mr. Bradley. So next on the agenda is Bill 250-34. And I'd like to call the following individuals who signed up to testify. Mr. Greg Massey with the Department of Labor and Senator Sam Mabini, also with the Department of Labor. As our island faces fiscal challenges and needs to make up for more than $67 million in lost revenue from the Trump tax cuts this fiscal year, many, including myself, have voiced concern that a tax increase was passed before options to make cuts or bring in new revenues could be explored. The purpose of Bill 250 is twofold. It would create a much-needed new source of revenue for our government through the Department of Labor, and it would invest funds into training local workers in apprenticeable trades with the Guam Community College. Currently, an employer seeking to hire a temporary non-local worker pays a fee of $1,091 to the Guam Department of Labor. These funds are divided between the Guam Department of Labor and the Guam Community College Apprenticeship Training Program, which assists in training our local workforce and helping people find work. Bill 250 proposes to increase the fee per non-immigrant temporary worker from $1,091 to $2,091, while providing an exemption for local construction not directly related to the military buildup. Civilian projects could maintain the $1,091 fee they had been previously paying. With the 4,000 H-2B workers that Guam is allowed through the 2018 NDAA National Defense Authorization Act for military-related construction projects, the increased fee could potentially bring an additional $4 million towards strengthening our homegrown workforce in needed areas like the trades. Both GDOL and GCC would receive an increased amount of funds if this bill were to pass. In the introduced version of the bill, each would receive a 50-50 split of the fee, which could mean that $300 more per worker would go to GCC and $700 more per worker would go to GDOL. But I am open to hearing feedback on these allocation percentages. DOL is currently mandated to use the funds to produce a quarterly unemployment report. I plan to amend the bill to ensure that Guam Department of Labor can also have administrative flexibility to do other research and reporting as needed, and to also utilize this increased funding to include the hiring of a staff attorney specializing in employment law, human resources, or administrative law. GCC's funds currently go towards financial assistance, administrative, and instructional costs within the apprenticeship program, as well as to advertising and outreach for their apprenticeship programs. I plan to amend the bill so that funds may be also used towards pre-apprenticeship program facility upgrades and equipment within the Guam Department of Education. This will assist in creating a pipeline for future workers and ensuring that Guam's youth are better aware of the potential careers in our island's most needed areas, and they have a foundation and an interest from a young age in further exploring these types of careers. Again, I want to thank Senator Sam Mabini of the Department of Labor and Mr. Greg Massey for joining us this morning. And I'd like to ask for you to just state your name for the record and proceed with your testimony.
Sam Mabini, the Department of Labor Director. I will have Greg start first.
Morning, Senators. I just had, I submitted written testimony. There's just a couple minor changes that we wanted to suggest. I won't read the testimony, I'll just kind of paraphrase it, but in section 1 on page 2, line 8, in the past we had had some questions from employers about prorating of the fee. At times, employers had wanted to prorate what we call extensions. A worker would initially come in, and then they would extend their stay for a period typically of up to a year. Sometimes they would, if the workers leave a little bit early, they would ask to prorate that at the back end rather than the front end. I suggest putting in the line, the registration fee shall not be prorated for workers who are renewing annual registration as a result of an approved extension of stay. And the reason being is if a worker leaves, they can always, and if they have an approved extension, they can always come back in. We wouldn't want to refund that fee and then the worker comes back in to work. It's almost like gaming the system. On the second part, the fee waivers, that was the one that we kind of really, I mean, there was a lot, in the bill there's a lot of flexibility, and you know, of course as an agency we love flexibility, but it would be kind of hard for us to apply. So I suggested in my testimony there are some bolded parts that we suggested. In essence, basically, instead of giving us the ability to waive up to $1,000, it'd be just straight $1,000. We may have future generations of, you know, administrators or directors come in that say, well, I'm going to waive this guy $1 and this guy $500 and this guy $800, and you know, it would be kind of hard to have consistency. If we just said, now again, going on further, we would also want it for, I guess the intention of this rebate, should the legislature want to do it, was to not harm the civilian, not increase construction costs for our civilian projects and our GovGuam projects. So I would suggest putting in the word exclusively. So if workers are working exclusively on civilian projects, because again, you could have a combination of some federal projects, some local projects, and then have an employer come in saying, well, you know, I've got a $35 million federal project, but I've got a $200,000, you know, family home, and I want the discount. So by saying that if an employer is working exclusively on civilian projects, then it meets that to some extent. And it makes it a lot easier for us to apply. I mean, how do we do it then? Are we going to say percentage-wise you get this much, or, you know, so it just, when we were looking at it, applying it was a little bit complicated. The other thing would be to tie it into their labor certification. In the labor certification that the Department of Labor processes, there's what's called a project summary sheet. It's basically a list of all your projects. And that's what the approved projects are for that batch of H-2 workers that comes in. So at least that gives a document so that we would be able to say, this is what we're basing. If you're going to say that if they're working exclusively on civilian projects, then that's the document you're going to base it off of, versus the employer saying, well, you know, I might have some civilian projects in the future. You know, it takes some of the uncertainty out of it and kind of protects us from any, you know, claims of, hey, you know, you guys are not being fair, you know, so we wanted to just put that in. Again, just for you folks to consider. The last thing that we had was on the section 4, subsection A to B, line 3. I kind of, on this again, suggested maybe just some really small changes. Right now it reads that the primary intent is to develop workforce positions currently approved for non-immigrant temporary workers in consultation with the Director of Labor. I suggested maybe saying positions strike currently, but typically, so that way, you know, where would we apply currently? Is it right now? Is it during the budget cycle? You know, when do we do that? If we say typically, then we can use like a 3 or 5 year trend to see what the demand occupations are, and then say that those are the actual positions that, you know, we want to focus training dollars to. And also, a small change, instead of saying in consultation with the director, you might want to say as determined by the director, so that we know who actually comes up with this list. You know, right now in consultation, is it, you know, the workforce board? Is it, you know, the president of the college? Is it the director? It's going to be kind of murky on that. And then sticking in a date of January 1st of each calendar year, so that way that list will be ready for the budget cycle, you know, going forward. Again, just suggestions that we put in. And that's kind of all I had, and I'm open for any questions that you might have. Thank you.
Thank you very much, Mr. Massey. We'd also like to invite up Dr. Mary Okada from GCC, who signed in to testify. Thank you, Senator Sam.
Yes, thank you, Madam Chair, for allowing us the opportunity to testify, and in this case, in support of Bill number 250-34. And I don't have a written testimony, but I wanted to be here to be available to answer any questions, and to also support the testimony that Mr. Massey had presented. Again, I appreciate the senators to recognize the original intent of the fund in the first place was to really fund apprenticeship training, in this case for high demand jobs in order to reduce dependency on foreign labor. So in all that we do, we should always remember what the intent of the funding is. The two concerns that I have that I just want to make sure that the senators review when they deliberate on the bill is, again, that we should focus on the high demand jobs on Guam. In this case, what brings this to light is the continuous need by businesses to import foreign laborers. So that's one side of the formula. The other side of the formula is what our labor market is showing, that in general, there's also labor market information that talks about all the different high demand jobs in Guam, or where all the jobs are. In this case, majority sits in our tourism industry or our retail industry, services. The top four right now is services, number 1, retail, trade, number 2, Guam, 3, and 4, construction. But what brings this to light is, of course, the other side of the coin is just the foreign labor, the desire to reduce the dependency so that we can focus on maybe addressing that high demand area. The other thing that I wanted to ask the senators to also consider as they deliberate is that we should consider the method of funding needed to provide the training that employers want or need, whether it's Guam Community College or any of the other training providers that are out there. So, and I know, and I'm grateful to the college for having partnerships with some of these training providers like the GCA Trades Academy. But keep in mind that businesses like the construction businesses who come to the Department of Labor specifically have their employment training needs, and with registered apprenticeship, they design what trainings they need, and they go to the college, they go to a training technical school, whatever they need. Sometimes it's even online. And so we have even a situation like that too, where some businesses want to do an online training. We can't use our federal funding to do that, but with programs like this, we have that flexibility. So at the end of the day, for me, the thing that we should recognize is that we have some mechanisms in place to address the high demand jobs. What are those numbers? What are the occupations? So we do have the Guam Workforce Development Board, and there is a combined state plan which includes the Department of Labor, Guam Community College, Department of Vocational Rehab, partners to work together, because at the end of the day, we're trying to get the general people of Guam into the workplace. Other solutions where this funding can help, and you alluded to this, Senator Biscoli, about working with schools. We need to build awareness about these jobs. We need to encourage businesses to also invest in the training. The funds look big on paper, but if we divide it by the amount of the cost it trains, the cost to train, the numbers of how many we can train starts dwindling. We need to look at how we do our training, how our schools do the training, and build programs that work for businesses. And the last but not least is, again, increasing the funding support. Currently at the Department of Labor, all our funding comes from our federal grants. Although we do collect MDF, that's really for the operations at this point, because nothing much is left for training. So this would allow that. Not to mention, even if this didn't go through the existing, with the existing formula, with the anticipated growth in foreign laborers coming in, that number will still grow. But our interest is how else can Department of Labor receive funding to support training that is in demand other than our federal funds. So we want to grow less dependent as well on our federal funds. Granted, there is news from Washington that there's going to be increased funding support, which is great news, but I think I believe they want to see that we're taking ownership as well to fund the growth of our local workforce. Thank you.
Thank you, Senator. Dr. Okada?
Hafaday, Honorable Senator Lee, and members of the Committee on Innovation, Economic, Workforce, and Youth Development, Senator Terlahi and Senator Torres, thank you for your attendance here at this hearing. As the president of the Guam Community College, I thank you for the opportunity to submit the following testimony in partial support of Bill 250-34, an act to amend subsection 7119 A and C, and to amend subsection 7120, and to add a new subsection 7119D, all of Chapter 7, Title 22, Guam Code Annotated, relative to the developing a local skilled workforce on Guam by increasing registration fees of non-immigrant temporary workers. GCC has administered the apprenticeship training program for our island community for many years. Furthermore, GCC has developed partnerships with the following businesses on Guam who have actively participated in our apprenticeship training programs. For example, Nissan Motors, Atkins Kroll, Docomo Pacific, GTA, Cabris Marine, Guam Department of Corrections, Guam Police Department, Guam Power Authority, Department of Land Management. These are a few of many businesses that we support. Currently, GCC has 450 apprentices in 85 occupational areas that include but are not limited to automotive mechanics, carpenters, masons, corrections officers, police officers, electricians, electronic systems technicians, child care development specialists, and customer service representatives, IT generalists, surveyor assistants, and welders. These apprenticeship students attend classes at GCC and work during the day to support their family members. These are hardworking students who are trying to improve their own lives and those of their families. And our apprenticeship program is successful. In just the past 5 years alone, the GCC apprenticeship program has produced 362 journey workers, with 2017 having produced 103 journey workers in 16 professions, our highest number of graduating journey workers to date. These are people who are considered experts in their profession, and they are helping to make Guam's workforce stronger and more productive. As such, we have some concerns on the proposed language in the original bill. We offer the following requests for consideration, and I did hear your introductory this morning, but I had already prepared this, so I'd just like to read it. Section 4A, 50% of the annual revenues generated shall be allocated to the Guam Department of Labor. This amount should not be 50%. As an example, if the revenue to support apprenticeship training programs is at $4 million, the cost to support the administrative aspects should not be set at 50% or $2 million. More money should be used for the program. In many programs, like federal grants, anything more than 25% indirect cost is considered high. The current allocation is at 30%. Section 4B, 50% of the annual revenues generated by the shall be allocated to the apprenticeship training program at the Guam Community College, with the primary intent to develop workforce for positions currently approved for non-immigrant temporary workers in consultation with the Department of Labor. This language is not necessary. Although it does not say shall, there should be no reason for GCC to have to consult with the Department of Labor to determine which programs should be considered for apprenticeship. The U.S. Department of Labor identifies and defines the apprenticeable trades. Through the approval of apprenticeship training standards, the coordinator from the state apprenticeship program at the Guam Department of Labor already provides guidance and approvals to these programs. Additionally, by statute, GCC's purpose is to establish and maintain short-term extension and apprenticeship training programs in Guam. In years past, GCC has used the MDF funding to support other areas in workforce development. This is the reason why there are not too many requests for H-2B workers in other areas. The continued funding for these additional areas would help to support workforce development needs for our entire community. Section 4B1, direct financial assistance to students enrolled in this apprenticeship program, where it says, any unused portion of this allocation under this subsection shall be returned to the MDF. Budget laws in years past have included the following. In addition to the authorization contained in subsection 7120 of Chapter 7, Title 22 GCA, this appropriation shall be available and authorized to be used by GCC to fund the operations of other programs at GCC as approved by the board and administration of the college after all the apprenticeship program requirements and obligations have been fully funded. And this is currently in the public law this year for the 2018 budget. GCC feels that this language is necessary and retained because in times when MDF funding has been low, the college has continued to support the apprenticeship program. This language helps to sustain the program and the apprentices enrolled in the program, even when funding falls short. As an example, during fiscal years 2012 to 2014 and 2017, GCC didn't receive its full MDF appropriation. In 2017, GCC was appropriated $1.094 million, but received only $147,165. I also strongly recommend that language be added to Section 4B3 to include facility upgrades and equipment to career and technical education or pre-apprenticeship programs offered by the Guam Community College at any of the Guam Department of Education public high schools. This will allow GCC to upgrade facilities and equipment to support these programs and the increased tools needed to successfully prepare students for the workforce. Finally, if there's a need to identify areas of revenue generation, I strongly suggest that the Guam Department of Labor identify fines associated with the enforcement of areas under their purview as a means to increase revenue. There is a mechanism to establish or update the fees associated with the administrative cost. These recommendations are respectfully submitted for your consideration in Bill 250-34. We respectfully request for your full support to make the modifications to this bill to allow the GCC apprenticeship and training program to continue to thrive. It is an investment in our students, our island businesses, and in our mission to provide the highest quality education and job training for Micronesia. Sidusmasi.
Sidusmasi, Dr. Okada. And I'd like to just see if any of my colleagues have any questions for the panel. Vice Speaker Terlahi.
Thank you, everyone, for your testimony. It's been very helpful. And Mr. Massey, I especially appreciated your testimony. I thought that the suggestions that you made are really good, especially on the Section 3, that exclusively, I think that's what we should be doing, yeah. Exactly that. And are there such certifications currently?
Yeah, that's part of the process. Before an employer can bring in an H-2 worker, they have to get a labor certification from the governor of Guam. So yeah, that's been in a process since the 80s.
Oh, I know, but I mean, I thought that that these were not being allowed anymore. Or are you saying that's different? These cover other areas.
The H-2 program it's still in place. It's just recently USCIS hasn't been approving petitions that have been going in.
So how many are there in existence now?
How many?
So are you anticipating that these will be approved?
Well, we're hoping. There's been two different avenues that have opened up. One is the change in the 2018 National Defense Authorization Act that allows for what we call non-temporary. Okay, let me step back. The reason there's been these denials is USCIS immigration has basically now, all of a sudden, after 30 years of giving almost 100% approvals, has turned around and said they don't think that construction the jobs that, and it's not just construction, they don't think that all these H-2 petitions that have been submitted in Guam are temporary anymore, based off of a really tight legal definition. So the 2018 NDAA turned around and says you don't have to prove temporary need for jobs that are directly connected to or associated with the military realignment. So that's opened a kind of a door for the buildup. The other path that just recently opened up was a preliminary injunction that was issued by the district court for the lawsuit that the Guam Contractors Association had filed against USCIS, basically saying that that change in policy wasn't done in line with the Administrative Policies Act, and that it was improper. So the judges has enjoined USCIS from denying those named plaintiffs based off of temporary need. Well, the reasons why they denied them in the first place. So that's another temporary path that's opening up. That's going to be in place until they hear the case on its merits, which would probably take some time. It might open up a little bit more if class certification happens. Right now it's limited to about 8 employers. So those are the two paths. We do see, there are petitions in for, I think, 11 employers right now, for a total of a little bit over 1,400 positions. So that's the beginning, and those are the test cases that are going in. I foresee if immigration starts approving again, that we're going to see that flood of applications, and finally a lot of these construction projects getting back to work, and that directly ties to this bill.
All right, so in the language that you're proposing, it says, as indicated in the project summary sheet in the employer's approved temporary labor certification. Project summary sheet.
Yeah, that's a required document in the labor certification.
And these are for temporary workers working exclusively on civilian construction projects. But then it says the or, so if you could look at that or in business activities not related to construction projects.
Yeah, because H2 is not all construction. We've got H2s now. Again, the large numbers.
So civilian construction or any other industry.
Non-construction, yeah.
Okay, and
yeah,
so
because
you're
otherwise
saying
the
that
bill
these
would,
paths are open.
Yeah, because otherwise the bill would limit it to just a construction worker. When we've got, and again, the numbers are very small. There's medical imaging, bakers.
No, I know. But yeah, I just wanted, all right then. So if all these paths are open, then this should continue to apply to all those industries.
Right.
Okay. And Senator Mabini, Dr. Mabini, you gave a list from one of your studies that was tourism, the high demand jobs, tourism, services, retail, and did you say Gov Guam and then construction?
The occupations fall in services. The top two are services and retail trade, which generally is related to tourism and everything affiliated. So it's services, retail trade, Gov Guam, then construction trades. Behind that is transportation, utilities.
Okay. And what do you, when you said we should consider those while we consider these bill, what do you think we should do with those?
Well, it's related to what Dr. Kata had shared in her testimony, that the training that they have provided, it's not just all about construction trades.
Okay.
There are other businesses, industries that have come to the table wanting to apprentice positions, and they fall under theirs, including telecommunications or whatnot.
Okay.
So it's just to consider that, in the heat of, and I think this relates to your question just a few minutes earlier, as far as, and that's related to the modification, that we should be not only focusing on construction trades, it's the other non-construction trades that are bringing foreign laborers. Of late, I looked through the list, and we have anywhere from AC and refrigeration mechanics, nuclear medicine technicians, radiological techs, even a scuba dive instructor. In that case, it's with specific needs, like maybe foreign language skills or whatnot. But so it's just considering that those are industries that we cannot forget, because there have been questions raised. Well, why are a lot of the funding training other than construction? Well, industries do have their need, and we cannot be discriminating. So we should be paying attention to the broad economic needs of our businesses.
Okay, I didn't think we were narrowing that, but I do appreciate, all right, your testimony. And Dr. Okada, I pretty much agree with your testimony as to the allocation, and I wanted to let you know that. And I just had one minor question, and that is, when you talked about making an amendment to section 4B1 to include language that, 4B3, facility upgrades and equipment are already allowed, but this one would be specifically for programs offered at any of the GDOE public high schools. So do you not need this for GCC campus, just primarily for the DOE campuses?
So yes, the current language already allows us to upgrade facilities and equipment on the GCC campus. But oftentimes we find that upgrading some of the equipment or the facilities and the GDOE facilities helps GCC programs. We have 11 programs, 11 career and technical education programs in the GDOE high schools. And so sometimes when we do the upgrade to the GCC campus for the latest technologies, and although we do have some funding sources to support the secondary component or the pre-apprenticeship, it's not necessarily enough. So we want to make sure that when we do that, if we have the ability to do some upgrades to the programs that exist in GDOE high schools, that we're provided that flexibility, which is not currently.
That makes perfect sense. I read it wrong. I thought you intended to delete this and put for only, no, but you want both. Yes. Okay. Yes. Great. That makes perfect sense. Thank you very much. Thank you, Madam Chair.
Thank you, Vice Speaker. Senator Torres?
Director Rubini, approximately how many registrations are processed annually for this non-immigrant temporary workers with DOL?
Well, that's kind of a tough question, because what's normal is not normal anymore. We've gone through 2 years of pretty much zero approvals. Prior to those, in a normal state, I think the numbers, God, I can't remember right offhand, but we were typically doing about $1.4 million in total collections, with a 70-30 split, 70 to GCC, 30 to us. God, I mean, offhand, I can't remember the exact number, but it's several thousand, maybe 3,000.
I think where I'm getting at is I'm trying to understand what the trickle-down effect will be in terms of pricing. If we were to double the registration fees for workers, especially when there's prolonged activity, and I understand that the idea here is premised around a time frame, which is the military buildup, which is contemplated to begin about now and run to 2025, if I'm not mistaken. So it's a small window, but then there's also this will not sunset after 2025. So there's always going to be an effect on all registration fees to include temporary workers who. Now, are temporary workers necessarily temporary? Because the skilled labor, if they're non-immigrant, would contemplate that they're people that are resident of Guam? Or I'm just trying to understand who this pool is that we're assessing this fee.
No, the pool is only to those that are brought in under an H-2B visa.
Oh, only in that scenario. So then going back to my original thought, will this, I'm trying to understand if the impact of doubling the fee is going to have an adverse impact on the pricing of the services and the projects, and if that has been factored in, or if that's nominal and not an issue to be concerned with.
Well, I mean, definitely you're raising the cost by $1,000. Now, with if the discount portion goes in, then you're only raising the cost hypothetically to those federal, to the federal government. If we're rebating or if we're discounting $1,000 for civilian projects, so it wouldn't really increase cost of construction to GovGuam, like DPW projects, or to private homes or businesses. What that cost would be, it all depends. It's driven on how many workers come in for the buildup, and whether or not that cost is going to affect the federal government. That's something we would probably have to look into, but that's going to be something the feds would have to really look at more than we would. Now, if we just did without that the discount, yeah, definitely it's going to raise costs of construction somewhat.
My only concern is when we have a finite number that's been appropriated federally. I mean, we're always concerned that projects can be completed not only in time but at budget, right? And so and that's why I asked, well, how many people really are we talking about, and is that number significant to skew something one way or another? And that would be my only concern, although I note that I am one of the many co-sponsors of this bill, because we do need workforce development, and we do want to consider a way to sustain the efforts right now with the Guam Community College, and also the mission of the Department of Labor. But
well, Senator, just off the top of my head, I mean, again, we don't know what the numbers are because the sequencing of the projects, but if you use the 4,000 that say that it was max, and we use the 4,000 that the NDA is allowed to come in, that would increase the cost of the federal. Say that they brought in all 4,000, then that would be 4,000 times 1,000, so that's 4 million, 40 million.
which may not actually be the situation, because it is a phased out type of development.
Right, it's going to be up and down.
As opposed
but
to,
that would be the high end of what the impact would be to the federal government, 40 million, I believe.
So in your estimate, doubling the fee would not be an impractical consideration? Do you have an opinion on that?
Personally or professionally?
Well,
personally, I mean, it shouldn't have much of an impact with the discount in place, but I'm, also the kind of person that I don't like to raise stuff if I don't have to. But in these days, I mean, the fee was 15 years ago was $200, and it's gone up a lot. But I get it. We do, need I mean, on the side of funding training, I'm all for it, because we do need to kind of not stop. We will never stop relying on imported foreign workers, because you can't bring in 5,000 workers and then when the projects are done, you've got 5,000 unemployed people. You've got to be able to phase in and phase out. But if we can train up a new generation of local workforce with this, that maybe it's a good thing.
And perhaps that's where, Dr. Okada, you would agree that an infusion of this type of money into your programs will only facilitate the GCC in graduating more people that can then fill in the voids right now on Guam, and lessen the need for continual H-2B labor force. Is that
Yes, ma'am, that's correct.
simply the idea here? Okay. No, thank you for your testimony. Your testimony also. A lot of the things that I had some concerns about, you've addressed. So I appreciate you taking the time to not only appear here, but to provide written testimony that we can chew on a little bit after the public hearing. So, Sidzus Maasi.
Thank you, Senator Torres. And the Vice Speaker has one more question.
Yes, thank you. So this bill, it raises the fee for the H-2B visa registrations, but it creates this waiver that the Department of Labor can waive the increased fee, the entire amount of it at this point, for those working exclusively on civilian construction projects or in business activities not related to construction projects occurring on Guam. All right, then would this increased fee then, it would apply to companies who were going to bring in workers for strictly civilian construction projects? No.
Well,
Exclusively on civilian construction. Okay, if it's exclusive, all right. So my question was, the amount. So if we were going to, what if we changed the amount and made it higher? This registration fee, but included the same language as to the waiver of the additional amount for the same exclusions that you have here, or that we have here and that you've suggested language for. Do you have any objection to increasing the amount?
Well, Senator, you're putting me on the spot here.
Oh, well,
my friends at the Contractors
I'm
Association
actually...
are going to shank me. I mean,
well, it's curious that they're not.
Personally, I mean, I know that I leave it to your guys' judgment whether or not what it should be. I personally think that with the increased numbers, there's going to be an increase in those funds. But I also know that, you know, we're in hard times right now. Maybe a sunset. I mean, would it matter if you? It won't matter if that exclusively is in. It won't increase the costs locally.
Correct.
But at some point, we got to be careful. And it goes to Senator Torres' thing. At some point, are we going to increase the costs and have the military decide not to engage in certain projects? Or are we going to push it to the point where maybe the federal government decides to try to challenge it? I don't know. I'd be very careful. I mean, we can push it to a certain extent, but if we push it to the point where the feds say, well, I'm going to sue you guys because, you know, this is an H-2 thing, and H-2 is in our wheelhouse, you know, not the local wheelhouse. You know, I mean, on a personal standpoint, I feel that, I mean, it doesn't help us this year or next year, but in the next 3 years, the numbers are going to be so huge that...
Can you tell us what you expect number-wise? So you don't expect 4,000 pursuant to...
I expect, you know, and again, this is all crystal balling, but I expect by the end of the fiscal year, we should at least be back to status quo. But
by the end of 2018?
By the end of this fiscal year, we should be back to up to about 1,500 workers at least. I expect, looking at the charts that, you know, from the industry forum that we were just in, that 2019 is going to be significantly higher, and 2020 is huge.
2020, when you expect 4,000 is the cap.
4,000. Yeah, okay. 2020 and beyond is we're going to reach we'll probably reach the 4,000.
All right.
Yeah, the peak is in 2022, and they're saying that we need 10,000 workers. Of course, you know, about 4,000 are locals, so that's a gap of, you know, 7,000 workers. I mean, the numbers are huge. You know, and all of those are going to be probably H-2s that are going to come here and then leave. So, you know, it's going to go up and down. But, I mean, I get it. You know.
All right. What about, I guess, since you're here, if you don't mind, Senator Mabini, if about the fees or the fines, is there anything in that regard that we could help you with? Or are those in place? Or they need to be established? Or we just need to enforce them?
Did you say fines?
Yes. The GCC's testimony had suggested that if we're looking at areas for revenue enhancement, that perhaps the the Department of Labor fines with the
Yeah.
enforcement of areas under their peer review?
We already have that. We've been doing enforcement for 25 years. We already assess fines. The problem is we're really good at, enforcement is not all about got you, I'm going to give you a fine. We do a lot of outreach. We do a lot of training. We do a lot of corrections so that there's compliance. The fines are the last result, to force compliance, but we're pretty good at it, so our fines stay relatively low because we've got a really good rate of
them in
keeping
line.
people in compliance.
All the way
So the
along.
fines in itself, it's just, I hate to say icing, but it's not something you can really rely on because when we do our job, the fines stay low.
I see.
Yeah.
All right. Yes.
No, I just want to thank Greg for stepping in. He's been, I rely on him a lot because of his institutional knowledge, and we've gone around in circles regarding this. And it is true, a lot of our efforts have been in outreach. And don't get me wrong, there are violations or whatnot, but as far as the numbers that are coming in, the amount of fines that we could potentially collect is still pretty minimal, not enough. But, to answer your question.
All right. Thank you very much.
I have another question in that regard. Do all of the fines go to GDOL? All the fines go to the agency?
Yeah, in the statute, the fines do go, 100% goes to the agency, and it's limited for use just to support the enforcement programs.
Are there other fines that GDOL assesses in other departments that don't go to the agency?
Yes, fines could be in workers' comp that go to general fund. There's fines in wage and hour that, we're the only, ALPCD, fortunately we were, back in the day we went and got the idea to redirect the fines to support the program. So one of the things that we've done at ALPCD is we're almost self-sufficient when it comes to having fines and the MDF support us. For the past few years, we haven't asked for any general fund money. But other divisions haven't had the chance to do that. So there might be some in workers' comp, wage and hour. Fair employment, we just recently did the Fair Chances Act that allows for fines to be redirected under Senator Torres. And she listened to us when we talked about making sure that those fines go back to, and of course, again, with any compliance, when you do your job, you don't count on that as a funding source because when you do a good job, there's no violations. But it helps you get the copy paper and the new computer and maybe fund a vehicle that you need to do those things. It doesn't really support manpower and other stuff, though.
I also have a question for either Greg or Senator Sam. Who is the Guam State Apprenticeship Director?
The designation is at Department of Labor, so I'm the state director of apprenticeship. So related to Dr. Okada's testimony, the approved list of apprenticeable positions are produced and recorded over at the Guam Department of Labor. So every year we go through this list, and if there's any new positions that the community wants to add to the list, we take that in a public hearing, and then we send it up to USDOL so they know that that's the approved list. And that's the approved list that actually we use to also accept the incentive, the GRAP incentive for tax rebate. So that's the existing list. So I appreciate, by the way, I wanted to clarify that with the Guam Workforce Development Board and GCC as our partner, we do have this, and I've had several discussions with Dr. Okada regarding the challenges in attracting and training individuals in these high demand areas. And so I do appreciate that language as far as the consultation with the department, only for the purpose of being able to at least confirm and clarify that these are high demand areas that we should be, paying attention to and not neglecting. And that would be, the purpose of that. So I do appreciate that. That was in section 4.2. Yes.
If there are no more individuals who'd like to testify on Bill 250, we'll go ahead and wrap up. Again, I just want to thank you all. Thank you all from the panel for participating, Senator Sam and Mr. Greg Massey. Oh, sorry. There's one more question from Vice Speaker.
I'm really sorry to delay this. I just thought of it. But is health insurance required for these H-2B visa applicants?
Well, Senator, you're throwing out some bombs there. No, health insurance is not currently, there is no statute that requires health insurance. I know that when we first looked at the Build-Up 1 before it fizzled, there was a push to do some of that. It all started with health screenings, and then now there are, for almost all military contracts, they're requiring that the employers provide health insurance as a contract requirement. But there's no statutory requirement in Guam law. And the reason being is that when they started going, I think we went down, I forget what senator it was that was starting, but basically what happened was any benefits that a foreign worker gets, the employer must extend at least that same or better benefit to a U.S. worker in the same occupation. If you're going to mandate health insurance for an H-2, then you've got to mandate it for all of his U.S. workers also. And then when you get into that, then you start going down the rabbit hole into the haves and have-nots, and it almost starts looking like mandatory health insurance for the whole island. And at that point, back then, I don't think they were willing to go to saying, make Guam a mandatory health insurance state like Hawaii or some other states.
Well, I remember that we had an issue of that the hospital, right? The GMH, they talk about treating patients who were not covered by insurance, and some of these were, the non-immigrant workers.
Yeah, but when you went and looked at the actual list, there was like maybe one or two, and the rest of them were not truly H-2s. They were just foreign people, or people that had come on other visas. And
are you able to tell us or show us something that confirms that the military contracts are requiring health insurance now for their employees? If you have that available, could you just send it in?
I can ask JRM or someone for NAVFAC for a statement, but I don't have their actual contracts. Oh. Yeah, but I mean, it is. Let me see what I can get you.
All right.
It'll probably be just some briefing sheet or something from them, but.
But for all the other companies, it's not a requirement right now.
Not for health insurance. Now, keep in mind, anything that happens on the job is covered by workers' comp.
All right.
Right. So a health insurance would cover, like, if he gets sick at home or gets into a fight or something like that.
Yes.
Yeah.
All right. Thank you very much.
Thank you, Vice Speaker. Senator Torres.
Dr. Okada, in your testimony with regard to the Manpower Development Fund, is it your position that the statute should remain insofar as the apportion? Under Section 4 of the bill, Section 8, the figure was changed from 30% of the annual revenues generated to go to the Department of Labor. And under Section B, it was changed from 70% to 50% to go to GCC for its apprenticeship training program. So are you suggesting that, based on your testimony, are you suggesting that rather than changing those figures that it remain the same in the statute, that we not change it upward? So in other words, GCC will continue to get 70% and Department of Labor will continue to get 30%?
So in my testimony, of course I would like it to stay at 70%, but in my testimony, I was referring to the 50-50. In most federal contracts, anything above 25% administrative cost is really high, and we're currently at 30. Right. So, and I say this because if it's a $4 million revenue source, and it's going to cost $2 million for us to monitor it, that doesn't make sense. Right. It really needs to be put into the training component. Now, and the reason why I said that is because of the current 50%. in the bill.
Right, right. And I
Of
agree
course,
with
I
you.
would advocate that 70% is a reasonable amount, given that it's considered right now 30% indirect cost. But if there's some flexibility that needs to happen, I just ask that it not be 50%, because I think that's too high. So I would like it to remain at 70, but if there's, you know, a 1%, a 2%, or something a little bit smaller that needs to give, then I'm willing to, I'm willing to support that. The reason why I honed in on the indirect cost is because, as I mentioned, in normal federal grants, 25, anything above 25% is considered too high.
And I think in today's age, we're a little sensitive to all those indirect costs and the discretionary spending that's been happening in a lot of the agencies right now. So your point is well taken. And I think that if the objective here is to develop manpower development, the manpower development fund, then clearly the bulk of the funds should be, any gain should be applied to that. I mean, that I understand. But I just wanted to point that out, because as we're looking at recommended changes and the rationale behind them, you know, we want to be clear about what the net gain is going to be to GCC in applying a greater portion of that gain as a result of the increased fees. But no, thank you. I just wanted to be clear about your position.
Thank you.
Thank you, Senator Torres. I also just wanted to reiterate that the committee will remain open to receiving testimony on both bills, 246 and 250. Senator Sam?
Just as a follow-up, if you don't mind, to Senator Torres' inquiry, I agree with her and with Dr. Cotta. It should be going to training. And I noticed that on page 3 or section 4.2, where it talks about, where it clarifies, let me see, here it is. Oh, where is it at? Okay, excuse me. It is section 4.2, where it says the remaining balance of Department of Labor's MDF allocation shall be used for administrative and operational purposes. And perhaps to clarify that, then it would be administrative, operational, and training. Because yeah, that does throw it off. It's as if it's going to all go to the operation of the institution, which I don't agree. That in my earlier testimony, I pointed out that 100% of our federal funding, our training funding, is coming from federal grants, and there's no local pot of money to support training. It's if the federal government were to pull back any of those training fundings, we have no training funding, which is what used to cover or pay for the HRD, which is no longer in existence. It's now the American Job Center that funds that. So, and not to mention, under the Department of Labor, we have, I believe, 14 training providers, and some of them have approached the department asking how can they avail of some of these training monies, because there are other organizations like the Guam Trades the GCA Trades Academy or Mariana's. I printed out the list of our various training providers who are wanting to be able to support the training needs of the community, like the Center for Micronesian Empowerment, GCA Trades Academy, GCC's on the list, Guam Marianas Training Center, New Horizons, Pacific Human Resource Services, Pacific Islands University, University of Guam. All of them are wanting to avail of some training support funds to be able to help continue supporting the occupational training needs of the businesses. So that would be the reason why that extra funding would be helpful. It would be another way for us to support. Not to mention, when it comes to our federal funds, we have very strict criteria of who can avail of those funds. When they come in through the department, then there would be that flexibility. Those funds are provided for those who are in most need of support. Those who have significant barriers to employment, those who have priority of services like veterans and so forth. But that's the federal funds, so we have to follow their strict criteria of how to spend those money for training. With local funds available to the department, we'd be able to now say, well, there's another source for training that's not contingent on all some of those strict regulations. I would imagine that the Guam Workforce Development Board would step in to help guide the spending of those new training funds should this occur.
Thank you, Senator. I just want to reiterate that we'll keep the record open, and we plan to include all the feedback that we receive on both bills, 246 and 250. And I just want to thank you all so much for participating. Dr. Okada, thank you very much, and Mr. Massey and Senator Sam for your very constructive feedback, and we'll be sure to incorporate those into the bill. We'll amend it, the committee will. And I also very much want to thank my colleagues for joining me, Senator Camacho Torres and Vice Speaker Terlahi for their input as well. Again, Sijuas Masi, Todas Hamzu, Porifinatan Midzu Pagu. The Committee on Innovation, Economic, Workforce, and Youth Development has duly heard bills number 246-34 and 250-34. Again, individuals who wish to submit testimony will have 10 days from today to do so by emailing it to Senator Bisco Lee at guamlegislature.org, or you may hand deliver a copy to 136 Chalan Sancho Papa here in Hagåtña. This hearing is now adjourned. It is 11:31 a.m. Sizus Masi.